Good day, ladies and gentlemen. Welcome to this information session with us. My name is Cordelia Fourie. I will be your presenter for this course. Today, we are going to look at some of the SARS guidance that has been issued on the immigration issue, what is happening with our lump sums if we want to withdraw it, what is happening with the immigration process itself. So on the agenda for today, we're going to just do a brief recap. What do we know? What happened under the old process rules? What is happening under the new process rules? What guidelines has SARS issued? What guidelines has the SARB issued, the South African Reserve Bank? We're also going to look at their guidelines very briefly today. Ladies and gentlemen, just note today's purpose is not to look at all of the rules with regards to residency, all of the rules with regards to exchange control, what foreign investment allowances or foreign capital allowances there are available. We have provided as many links as we possibly could to the SARS website, to the SARB's website, the Financial Surveillance Department, that has a list of those documents, all the dealer manuals, etc. But today, we're really not aiming to look at all of those things in detail. Today is aimed to be an information update on the issue of immigration and the withdrawal of lump sums specifically. So we're going to keep it we're going to keep our discussions around that, and any other matters you would then have to ask about if we do not deal with that. And then, of course, we're going to look at some of the questions that have been left unanswered dealing with this immigration and lump sum withdrawal issue, especially with regards to the effective date that we're looking at. There were a lot of questions surrounding that. Unfortunately, we might not have the answers from our side, but at least we can soundboard, we can discuss these matters, and then as we go along together, hopefully we do find some more insight from SARS' side. Unfortunately, there hasn't been much said in these areas with regards to those questions that have been left unanswered. Right, so looking at what we do know, we know that under the old process, we had to go through a rigorous administrative thing with the South African Reserve Bank if we wanted to emigrate. And the recent changes in the immigration process simply just, it scrapped all of those administrative burdens. So the one thing that we did see that we don't have anymore is the MP336B. It no longer applies. You will still apply through the South African Reserve Bank. You will simply not apply for tax clearance with your MP336B. So the main impact, I believe, is on the tax side of things. It's not necessarily that you don't have to work with the Reserve Bank at all anymore. You still need your authorized dealers. You still need to go through the majority of the old process. Actually, it's just the admin surrounding it that has been changed up a bit. So the MP336B is no longer with us, and the tax compliance that you now need to get, the tax clearance, in order to be able to immigrate and basically shift your funds out of the country and all of your assets, that is what has been impacted. You now have to obtain a TCS PIN. That is what SARS calls it, or you can still call it tax clearance if you want to, or just your tax confirmation, whatever you want to refer to it as. You have to apply directly through SARS with the TRC01 application. We are going to look at that process briefly today, how it works on e-filing for the individual, also talk a bit about your representatives and your practitioners, what you need to know about that. But then, of course, it also impacted the withdrawal of lump sums. And that's where everybody started losing their minds, because now we can't access our retirement funds anymore. Ladies and gentlemen, that's not necessarily the SARB's fault. It wasn't the Reserve Bank that said, now the retirement funds cannot give you your funds anymore. That was due to a change in tax legislation. And because the legislation was changed, it changed the definition of your retirement annuity funds, your preservation funds, to only allow the funds to actually withdraw, or allow you to withdraw the funds once you have been a non-resident for tax purposes, not for exchange control or anything else, but for tax purposes, for at least 3 years in a row. Previously, they did allow that you could withdraw the funds if you simply formally emigrated through the SARB. So if you had your MP336B and your tax clearance, etc. But now that doesn't work like that anymore. You need 3 years non-residency. Now, ladies and gentlemen, this 3 years isn't necessarily 3 years of assessment. The Act doesn't specifically define a year. It does define a year of assessment, however, but the wording says for 3 consecutive years or uninterrupted years. It doesn't refer to any kind of specific year. So you should be able to argue that it could be a calendar year, it could be a financial year, whatever view you are taking on that. The Act just says years. Right, and then of course some of the exchange control limits were also lifted. Your blocked funds counts are no more. They do have some stringent verification, of course, for certain offshore transfers that we'll look at a bit more when we look at the SARB guidelines. But there have been quite a few changes that in National Treasury's view, it did make the process easier. So from the individual taxpayer's view, it might not seem like that, but from a policy view, I suppose that is where it genuinely came from. That is where it originated from. And then, of course, as a transitional measure, they are still allowing those that have applied for immigration and that had their forms attested, basically stamped by the authorized dealer, your AD, which is basically a bank or a financial institution that assists you through the process. All of those that have been received by the SARB or submitted to the SARB before the effective date. So the effective date was technically the 1st of March when the law changed. So the 28th of February was the cutoff time. That will still be considered under the prior rules, which means the moment that it is confirmed and you've emigrated and the SARB has finalized all of your documents, you should still be able to access your retirement funds. But this needs to be finalized by the 28th of Feb 2022. Later on, we'll talk about what happens when it's not finalized. Whose fault is it? And can I then still access my retirement funds? So when we refer to the prior rules, ladies and gentlemen, we simply refer to the withdrawal of lump sum benefits because that's what everybody's been worried about. That's what everybody's been complaining about and asking the questions. That's what the prior rules refer to. Everything else, of course, the process might now have changed. So SARB might ask you for different documentation, etc. Don't get angry at them. They have to stick to their own rules as well. Now, of course, there has been quite a lot of comment with regards to this new 3-year rule. When the draft amendments was sent around before it was promulgated, a lot of stakeholders and interested parties made comments to it. And just some of the final comments for interest's sake, a lot of uncertainty actually still exists around the non-residency concept because it doesn't refer to what kind of residency test you should be applying. So in terms of tax legislation, there are 2, your ordinarily resident and your physical presence test. And the new legislation doesn't say how you should be a non-resident. And of course, those 2 sections are not nearly the same thing. They are actually completely the opposite. And there's also, of course, the uncertainty with regards to the 3 years itself. Is it 3 calendar years, 3 years of assessment? How do you now deal with interaction with DTAs, etc.? So in that case, if a DTA deems you to be non-resident, would you then be able to access your retirement funds? So there were a lot of comments on that. Quite interesting to see what people said on that. And of course, they also argued that using a tax residency test in the first place is very subjective, especially if you think about ordinarily resident, that it revolves around your intention. If the taxpayer cannot prove his intention, then it might become severely difficult for him to access his RAF. But unfortunately, not all of those concepts or comments, apologies, were accepted by National Treasury. Some of them were taken into account to look at the policy, to look at the legislation, to see if they can make it at least a bit more clear so that we don't have this issue of we don't know what's going on. We can't apply these rules because we don't know in what circumstances they would be limited or more strict, etc. And then on the other hand, we know that the remainder of the immigration process remained in place. You still need to work through an authorized dealer. You still have to ensure that the funds are properly transferred out of the country. It can't be shifted illegally or unknowingly to an AD, etc. And your FIAs and your FCAs, those rules have remained as established by the SARB. There are a few changes with regards to the limits that you could transfer, but the bulk of it, ladies and gentlemen, is exactly the same. So your family units, your individuals, your students, the travel allowance, all of those things have more or less remained the same. Now, ladies and gentlemen, please be very, very careful with this. Taxpayers still need to notify SARS when you cease to be a tax resident. That question is incorporated into your tax return. There's a question asking, did you cease to be a tax resident? And ladies and gentlemen, if you don't notify them, they might have the right to assume that you are a tax resident in South Africa, which means you are taxed as a South African resident. Now, of course, if you do notify them, it would trigger the application of Section 9 Cap H, the exit tax. Unfortunately, there's nothing you can do about that. That is in legislation. So if you cease to be a resident, you pay deemed capital gains taxes on almost all of your assets. There are a few exclusions, your fixed property in South Africa, your cash, etc. Now, of course, you might only be reporting to SARS that you cease to be a resident a lot later than you actually left the country. And of course, if your tax cycles, the filing season is taken into account, then what would happen if you only file your tax return sometime after actually ceasing to be a resident? Now, in short, ladies and gentlemen, if you don't want to be taxed as a resident after you cease to be a resident, then you have to notify SARS. You don't have to necessarily submit your return. I suppose you could do it on e-filing. You could request it and complete it and submit it. For example, I was able to request my return before filing season even started. But you have to be able to prove what date you cease to be a resident if you didn't notify SARS at the same time. Yes, of course, you could notify them via email, etc. It's not guaranteed that they will receive that communication or look at it. So if you want to be sure that you're taxed in the correct manner, resident and non-resident, then you have to be able to prove it. Right. Of course, if you cease to be a resident and you have submitted the information to SARS, then they will pre-populate the date on which you cease to be a resident on your tax return. If you didn't communicate it to them, then you have to submit it. You have to fill it in. And that's why you then have the onus of proving that date. Now, before we continue, ladies and gentlemen, I just want to make it extremely clear, this last part here. Financial, in quotation marks, because technically there isn't such a thing as financial immigration. It was just formal immigration. That's all it was. It was just an admin thing to get your funds formally out of the country. Immigration through the Reserve Bank has never been, and will probably also never be, a guaranteed break in tax residency. Tax residency rules, you'll see there for being ordinarily resident. It's based on intent. Being able to prove that you are not going to return to South Africa on a balance of probabilities with all the subjective and objective and whatever factors taken into account. And even if you are not ordinarily resident, there's still a chance that you will be deemed to be South African tax resident purely based on your physical presence, because those are the two residency tests that SARS works with. So they don't really care if you emigrated or not. That is one element, one factor that will be considered with your ordinarily resident test to determine whether you are resident or not. So please never ever think that immigration is an automatic guaranteed break in tax residency. It doesn't work like that. And then, of course, a lot of people have asked the question, with the Section 9H exit tax, what about my lump sums now? Because lump sums or retirement fund amounts aren't really listed specifically in terms of Section 9H. What the legislation does is it lists amounts that are specifically included, so your assets in terms of the 8 schedule, and then it lists a few amounts that are specifically excluded, your fixed property, anything connected to a permanent establishment, your cash, sometimes your personal use assets obviously would also fall under that because it is completely excluded from CGT. But when it comes to lump sums, they ask the question, will there now be a capital gain or loss? Because I cease to be a resident, which means Section 9H deems me to have disposed of all of my assets. And yes, retirement funds are included in the definition of an asset, but I haven't received the payout yet. So in terms of how the 8 schedule then works initially when it comes to lump sums, when you receive a lump sum benefit, it is technically excluded from CGT. But the problem comes in now because the lump sum hasn't been actually paid out. So you can't use the exclusion purely for CGT purposes to say, well, it's not a CGT asset. However, when we look at the rules for proceeds and base cost when it comes to capital gains taxes, because the deemed disposal will basically just run on that premise, then you're going to look at the element of proceeds that have to be reduced by amounts that will be included into gross income, and the base cost element that will be reduced by amounts that have been deducted from taxable income previously. So essentially, when we look at those two rules, lump sum benefits will be included into gross income eventually. It will be taxed on its own methods and tax tables, etc. And you are not going to include it as proceeds and as base cost. That is technically why when you emigrate and you have lump sum benefits that are sitting in a fund, you're not going to pay taxes on it yet, because the proceeds less the base cost will be zero at the end of the day. The CGT on it will be effectively zero. So it's not specifically excluded from Section 9H, but the net effect thereof will be that you won't pay taxes on it anyway. Right. We will discuss the proposed amendment that SARS has, or that National Treasury has suggested a bit later on, with how they want to tax these lump sums, because it doesn't fall within the ambit of Section 9H. If you look at all of the provisions of the 8th schedule, right, just everything read together. So you won't find it in Section 9H as a specific exclusion, but technically because it's taxed in terms of gross income, then you won't be taxed on it here as well. Right. And then there was a new thing that SARS brought about, a new web page that they put on their website for ceasing to be a resident. Now, this just provides a very brief overview. When someone is tax resident, when you cease to be a tax resident, what supporting documents may prove your break in tax residency. So it's really just a summary page. It's not really meant to be an interpretation note or very elaborate. We have put a screenshot on the next slide as well for those documents that might prove your break in tax residency. And then they've also just indicated there, how do you declare your change in tax residency. So if you do indicate it on your tax return, then of course that's the one way to do it. Or you can simply inform SARS by submitting a declaration. So they have indicated an email address there. As I mentioned, it's not always guaranteed that they're going to see it when you need them to see it. So you might also want to contact them additionally, call them, ask them, did they get it, etc. But if you have submitted it, at least you've done everything from your side that you could. Right. And then, of course, the declaration must be made the moment that you cease to be a resident. Ladies and gentlemen, you can't wait until filing season and then decide, oops, I have to declare myself as a non-resident, and then fight with SARS because you don't want to pay taxes as a resident. Please do it the moment that you cease to be a resident. And this means that you have to probably plan ahead. If you know you're going to leave the country, then get these things in order beforehand. Don't wait until it's too late. So this is just the documentary proof to basically substantiate your break in tax residency. SARS has there a list of standard requirements that has to be submitted regardless of whether you are ceasing to be ordinarily resident or physically present, or in terms of a DTA. But the rest of the details are linked to the specific residency tests. So you're more than welcome to have a look at it here or on SARS's website. It is readily available either way. You'll see that each of the tests, the documentary proof that is linked to the test, is driven by the actual requirements or the factors that you will look at when you are deemed to be resident under that test. Right, the next part of the SARS guidelines is actually for our fund administrators, but also for the individuals, just to distinguish a bit between the kinds of funds that the new rules are applicable to. You'll see that the 5 types of funds that the Act typically deals with are our pension and provident funds, the first 2 groupings, and then we have our preservation funds. Yes, they're pension and provident preservation funds, but I'm just going to call them preservation funds straight. And then we have our RAFs. Now, ladies and gentlemen, only these 3 groupings were technically affected by the change in the legislation. The definitions were changed to make provision for the residency, non-residency rule instead of formal immigration. Pension and provident funds, ladies and gentlemen, they didn't provide for withdrawals upon formal immigration anyway. So the changes didn't really affect them. And of course, pension and provident funds in the normal sense, they only allow you to withdraw your funds once you resign, once you actually retire or resign from your job. So the person doesn't necessarily have to emigrate to take the funds offshore, because they can utilize their other allowances, their foreign investment allowances. They don't necessarily need the immigration rules to allow them to withdraw the funds. And then SARS has a specific guide. This is now typically for fund administrators to request a directive. Of course, fund administrators need this directive in terms of releasing the funds. They cannot release the fund to the individual before they have obtained that tax directive. It's a pay-as-you-earn thing, basically. The fund administrators are seen as employers, and they have to make sure that tax has been withheld and facilitated before they can release the funds to the employee, which is now the individual member. Just a bit of background on this, ladies and gentlemen. In the old days, you couldn't access your retirement funds unless you actually retired. And then it changed for RAFs. You were allowed to basically discontinue your contributions before retirement date if you emigrated, if that immigration was recognized by the SARB, by the Reserve Bank, and then you would be entitled to a lump sum. Then it changed for preservation funds to allow the members that have already accessed their once-off withdrawal, your 1/3, which is prescribed in legislation. You can access the rest before retirement if you emigrate formally from South Africa. So they had similar rules for people who worked in South Africa on certain visas that related to RAFs. So now all the definitions were basically just aligned. They have been amended. As we've seen now, it doesn't refer to immigration anymore. It refers to the non-residency rule of 3 years in a row. All of the withdrawals, ladies and gentlemen, are still taxed under the relevant rules of the second schedule. They are withdrawal benefits, so nothing there has changed. It's just the when. It's not really the how that has changed. Right. And in terms of facilitating those taxes, then your fund administrators will have to apply for the tax directive. So in terms of this guide, just a bit of clarity on the reasons for the directive for fund benefit withdrawals. From the 1st of March, there's a new reason to be used, the cessation of South African residence. And of course, you might still use the immigration withdrawal reason if that application was already submitted on or before the effective date. So they still accepted it until the 1st of March. And then, of course, accepted by the SARB and finalized by the SARB on or before the cutoff date here, the 28th of February 2022. Right. Then for the supporting documents, of course, when you are still falling under the normal immigration withdrawal rules, because some of the individuals still are still able to utilize those rules, then you need a letter from your AD confirming the recognition from the SARB, because that is the rules that it was still attached to. But everything else is basically based on tax compliance. A copy of your tax compliance clearance or certificate, your tax compliance status PIN, a certificate of residence from the relevant tax authority. Ladies and gentlemen, please distinguish here between a certificate of residence. The guide indicates that that is for DTA countries only. For non-DTA countries, you need an immigration or a citizenship certificate. You can't use a certificate of residence because residence is a tax thing. And then if you use the new reason, the cease to be a resident withdrawal, you still need a certificate of residence that is not older than 6 months issued by the tax authority of the new country. And then you need some documents confirming your break in tax residency. And this is not a surprise because we just mentioned previously, you need to be able to prove your break in tax residency. Immigration is not enough. So the fund administrator, ladies and gentlemen, is here responsible to ensure that you have been a non-resident, because they will be held responsible for the tax directive process. And if they don't ensure your non-residency, they might allow you to get your funds or access your directive without complying with this rule. And then just in terms of what they may accept, passports from the new country, assessments that were issued by the new country of residence. The guide really doesn't give a lot of more examples, but if you use your logic, the fund should only accept documents that really prove those factors if you take into account the residency test. So what is the center of interest for that individual? Did he move his entire family? Are they now in a new school in the new country? Did they sell all of their assets in South Africa? There's a lot of things that you need to consider that the fund administrator may accept as supporting documents. But very important, the taxpayer is still under the obligation to inform SARS when they cease to be a resident. Why? Otherwise, the tax directive will be rejected. And then you're not going to get your RAF. And ladies and gentlemen, please don't get angry at SARS with this, because it's just fair to request a taxpayer to at least let them know. If you want your money, at least communicate about it. If you didn't communicate, you can't complain later on that your directive was rejected. I feel this is quite a fair thing to request or to require from the taxpayer. And of course, for you, it's more beneficial because then you have your things in place. It is up to date. The other guides that SARS has issued deals with obtaining a tax compliance status PIN. So we're not going to look at how to complete a tax directive, etc. today. The session is not specifically aimed at fund administrators, and SARS does have quite a few guides on that. But we want to talk about the tax compliance status PIN because individuals can actually request their own. So this first part is actually just for administrators or tax practitioners, those that manage taxpayer profiles, to ensure that you have the correct user rights so that you can request tax compliance for the people that you do the taxes for. So it's just to access the TCS functionality to verify their tax compliance status. So you've just set out a few steps here from the guide. Make sure you select the correct taxpayer, so your client, and then under organizations, rights group, you open the group details and you select these two elements, your tax compliance status and your tax compliance status verification. And then for those taxpayers, you should be able to use these functionalities. That's all this is. It's just to make sure that the functionalities are there. And with your organizations, with the profiles that are that organizations work with, you might need to go and ensure your user rights are ticked. Unless otherwise you won't be able to use those functionalities on e-filing. For the individual, however, you can go on your own profile, e-filing profile as well, to activate your tax compliance status. This just enables you to view this dashboard, the My Compliance dashboard, and this will basically display all the tax types that you are registered for, irrespective of whether it is active or not. But it will enable you to basically track your tax compliance. So for an individual, you will go to either tax status or tax compliance status. There's a top menu and there's a side menu on the dashboard, so that you can use in accessing that functionality. And then you have to select activation. Now the verification, your tax compliance verification, is simply for other people to check whether you are tax compliant. For you to track your own, you need to activate the tax compliance status. Right, so under the tax compliance status side menu, you will select activation. And then once again, go to tax compliance status, tick the disclaimer, and then click on activate. And then click on continue to go to the entity reference number confirmation. Now, I was quite surprised when I saw this. It's just a check of all of your taxes to check that you are what you are registered for, if it is recorded at SARS. I thought that I would have been recorded with SARS, but it seems like it's just an additional check. After I confirmed that step, it seemed like I was able to access all the compliance functionalities immediately on my side, on the side menu under the tax compliance status. So it's just an additional step. Don't get a fright when it pops up. Of course, if you are registered for something that doesn't pick up under this confirmation, for some kind of other tax, for VAT, etc., then you have to confirm that. So it's just to verify your details of your tax reference numbers. And of course, you have to be registered for at least one kind of tax, and an active taxpayer before you can complete these steps. And the steps are the same for an individual, for an organization, for tax practitioner, for all the e-filing portfolios. It's the same for the individual basis. Of course, for organizations, if you manage someone else's taxpayer profile, then you might have a few extra steps. Then you have to select the actual taxpayer that you are working with. Now, the guide also goes into detail with how to merge entities, if you have separate entities, how to view specified non-compliance issues, etc., how to remedy it. Just take note, some of the non-compliance issues cannot be resolved on e-filing at the moment. The guide gives specified items that are available. So you are welcome to try and resolve it on e-filing, but sometimes it won't allow you. So then you would have to contact SARS directly. And then, of course, the guide also explains how to challenge your tax status. If you are listed as non-compliant, how do you argue with that, right? If you do not agree with a non-compliant status. If you see a non-compliant status and you know what it is about, then you can try and remedy it yourself. You don't have to go and challenge your tax status. You can just try and remedy the tax compliance or the non-compliance by yourself. Now, ladies and gentlemen, when you work with this compliance status functionality, especially if you don't agree with a non-compliance status and you want to follow it up with SARS, you are able to do so via the e-filing platform. But please just take note that when you follow up with SARS on these matters, this is now coming from the OTO, a recent issue that they had, I think, from Fair Play, where they indicated that it takes taxpayers too long to resolve matters with SARS, and tax practitioners for that matter as well, because we keep following up with SARS. Now, it's very kind of you to try and be patient. I know we always promote trying to be patient with SARS and trying to do the right thing from your side. But in terms of SARS's service charter, they shouldn't take more than 21 days to finalize a query. So if you submitted a query or you lodged a complaint or whatever the case may be, and SARS doesn't resolve the query within 21 days, and you follow up the first time, don't follow up a second time, because then SARS is basically entitled to take 21 days every single time. So after you've followed up basically, and they don't respond and you don't get an answer, then the OTO, the Office of the Tax Ombud, has indicated that you should go to their complaints management office and lodge a complaint as well. If they don't resolve the complaint, then you should go to the tax ombud, because it's unfair towards taxpayers to keep following up and SARS keeps extending their deadlines. So just a brief note on that. Now, in terms of the immigration and your foreign investment allowances, there are additional steps to obtain your TCS PIN. So the previous step was just to make sure that you can see your tax compliance dashboard and the menu and to see what you can get. I'm just going to refer back to the previous slide. The screen that you see here is your compliance profile. That will show, are you compliant or not for each of the relevant elements. The second tab here, tax compliance status request. It's not a verification, it's a request that you submit to SARS, because this is where the immigration and the FIA comes in. There's a drop down to indicate what do you want to request your tax compliance status for immigration or for FIA. You could also select it for FIA, which is foreign investment allowances. And of course, this compliance status is what you'll need when you are permanently leaving South Africa. Right. Then it will open up the TCR01 form. You will have to complete it. Some of the fields will be pre-populated based on the information that the system has on file for you. And then you have to indicate whether the form is completed by a representative, in which case you have to complete the representative form. You probably need a power of attorney, etc. You don't have to be a tax practitioner to be the representative. It might just be that you are filling it out on behalf of someone else that you have the power of attorney for over their matters, over their tax matters and their financial matters, etc. Now, the guide has a list of supporting documents that are required for these compliance requests. They also explain how to cancel your PIN or request a new PIN, etc. We're not going to look at all of that. We are going to briefly look at the supporting documents on the next few slides. Now, when you request a TCS PIN for immigration, SARS will still ask you whether you will remain tax resident, because immigration doesn't mean that you break tax residency. Or they will ask you whether you anticipate to be tax resident within the next 5 years after immigration. Right? And then, of course, if you answer no to the first question, will you remain tax resident? The form asks you, where will you then be a tax resident? So you need to know these things before you apply for this TCS PIN. Otherwise, you would have to answer, yes, I will remain tax resident, and then you will be taxed as a tax resident. Right, now, in terms of this guide, this is now for the TCS PIN, not necessarily for your income tax return. They do make mention here of the exit tax. You have to declare your assets and your liabilities when emigrating. And then SARS indicates that for all of the assets on which the exit tax is charged, you need to supply the CGT calc as well. Right, on the deemed disposal. So you already need to approach a tax advisor or a tax specialist in this field to assist you with this if you're not sure. If you only have fixed property and nothing else, then of course, we've already told you fixed property in South Africa is excluded from the exit charge. But for other things, you might need to have to account for tax. And also very important, you will need to indicate the expiry date on your request. Your tax compliance status PIN is only valid for a certain period of time. So please take note of how long it is valid and don't be surprised when it isn't valid anymore. You could always go and request a new PIN for another valid period. So just take note of your expiry date. Right? You are in charge of that part. And then, as we mentioned, there is an additional functionality, the tax compliance status verification, but this is more for the fund administrators, basically, who receive a PIN from a taxpayer. Because once you've acquired your tax compliance status PIN, you will send it to the fund administrator along with all of your other documents, etc., and they can go onto e-filing and they can verify whether your TCS PIN is valid. Right. And so in terms of the supporting documents that are required for tax compliance or to confirm your tax compliance, this is now just for obtaining the tax directive. SARS requires similar information to give you your TCS in the first place because it links to the same thing. But of course, the fund administrator might ask you for similar documents. It doesn't matter if it's the same document, send it to SARS, send it to the fund administrator, then everyone has it. So for a first-time immigrant, and I believe this is also on their website, the supporting documents for immigration, as well as in the guide, you need a statement of assets and liabilities. And surprise, surprise, they ask you now for the previous 3 tax years. So not only do they want you to now become non-resident for 3 years in a row to access your funds, they also want to see what happened with your assets and liabilities in the previous 3 years, so that you can't just give them 1 year and hide a few things. Now, they do make a distinction here. Applicants who emigrated, so emigrated in quotation marks because simply they just left, they didn't formalize it through the South African Reserve Bank, or they emigrated a very long time ago, which some people actually have done. They are sitting in a situation, they left, they never notified SARS, they never emigrated formally, but now they need their funds and now they cannot get it because they don't have their tax compliance. It is a big problem. Right, so those who immigrated, those who left a long time ago, and they don't have any assets and liabilities in South Africa, you simply need to submit a null statement. You have to submit something, but you don't have anything to put on there, so submit a null statement. Then you should still be able to get your tax compliance and the directive, etc. But because you don't have anything left, there's nothing to put down there. And then, of course, details of any insurance policies, your pension, provident, retirement fund, the estimated values thereof. So you might want to liaise with your fund administrators on this to get a bit of information here. Details of any trust of which you are a beneficiary or have an interest in, details of your shareholdings. So typically just your investments, ladies and gentlemen. SARS wants to know what they are. And then for requests before the effective date, you still need your MP336B. If it is not applicable, then you want relevant proof that you cease to be a resident, which SARS has indicated separately on their website. If you have any CGT that you need to calculate on deemed disposals, you need to submit that as well. And we've mentioned that if you don't submit it yourself, but someone else does it for you, you need a power of attorney. So all of these things are quite logical. It makes sense that SARS asked for it, and they've been asking for it in all of the other sections as well. Right? The fund administrator might also want to ask for it. Then for supporting documents required for obtaining a tax directive to release your benefit fund, you also need a separate sheet that indicates details of the fund. So whether it's an RAF or a preservation funds, it will be the same kind of information. So that is still for the normal immigration. If you have already emigrated and you want to transfer your remaining assets, so you've already left, you don't want your retirement fund necessarily, but you want your remaining assets. Surprise, surprise, you still need your TCS PIN. And of course, because you would have emigrated under the old process, you would need your prior MP336B, because you should have had that if you emigrated previously. And then you need to indicate the amounts that you want to have transferred and the POA if necessary. Right. The website has a long list of other documents required to demonstrate the source of capital. We're not going to look at that today. You can read it, you can use it. It is available on SARS's website. We have included the links in the resource slide for you. Right, and then just with regards to the SARB guidelines, we've tried to just align it. We've just extracted some of the items that really link to the issue of the withdrawal of the lump sum and the tax rules, etc. So 2 of the circulars that were published recently link with this, but it is all available in the dealer manual or the authorized dealer manual as well, as far as I know. So the authorized dealers may allow the transfer of assets abroad, provided that they have ceased to be a resident, not the AD, the individual. The individual has ceased to be a resident and they've obtained a TCS PIN in respect of immigration. So all of this is tied in with that tax compliance status. You need that to get what you want. And then, of course, when they cease to be a resident, there is now one rule that says you may transfer up to 1 million travel allowance without having to obtain your TCS PIN. I think the only thing that changed here was the TCS PIN. The 1 million travel allowance, as far as I know, was this way all along. Right. And then with regards to the retirement funds, you may, the AD, very important, the authorized dealer may allow, which means you need the fund administrator to be successful in requesting the directive, etc. And you need the authorized dealer to allow the withdrawal from your retirement and preservation funds if you have remained non-resident for 3 years in a row. Right. And then the new circular indicate, well, not necessarily the new circular, but the second circular indicated here that requests by individuals who cease to be a resident on or after the effective date will only be considered by whom? By SARS, if they have been non-resident. So SARB and SARS, they do work together with this process. Right. And then just the last note here with regards to monthly pensions and annuities that are paid from registered funds. The ADs must require a TCS at least once a year. So even if you receive monthly annuities, you still need your TCS to be updated once a year. And I think the validity period goes up to 12 months. So you can request it for a valid period of 12 months. Now, the other exchange control rules, the other foreign investment allowance and foreign capital allowance rules that have been not really changed around. We've looked at the 1 million rule now. They will basically limit you. You cannot use any of the unutilized portion of your single discretionary allowance. They will only allow the 1 million rand allowance. And of course, you can still take your household and your personal effects up to 1 million rand. That can still be exported. And for that, you would have to go through the SARS custom declaration form so that the same processes apply there. I don't think a lot has changed there necessarily, but they have communicated it on these circulars and in the manual. Now, with regards to the 10 million, I know there was a change with regards to the 10 million rand. If you transfer more than 10 million offshore, then you will be subject to, they call it now, the more stringent verification process. We don't exactly know what that is. I don't think they have published any clear rules on that, but it simply involves a verification process by SARS, which would require tax compliance, etc. And then, of course, you would need approval from the FinServ. I call them FinServ, but the Financial Surveillance Department as well. So they are just going to check that you're not trying to shift funds that you shouldn't be shifting. But the moment that you are non-resident and you transfer more than 10 million rand offshore, then you have that more stringent rule. So essentially, we have 1 million without having to obtain a TCS PIN. Then everything else might be subject to the TCS PIN up to 10 million rand. And after 10 million rand, then you will be subject to more serious or more stringent verification processes. Now, we mentioned earlier on that National Treasury made this tax proposal during the budget speech. This is now back to taxing your lump sums. And they made a proposal to tax it when you cease to be a resident, even if you keep it in South Africa and you cannot access it yet. So I was really a bit confused with this, because first they say, no, you can't access your funds unless you stay non-resident for 3 years. And then they say, no, we want to tax your funds even if you haven't accessed them yet. So I almost want to say they must just make up their minds and decide what they want. Do they want you to get the funds and for them to get the money or not? Now, the problem with, or the reason that they made this proposal is simply the fact that your retirement interest that remains in South Africa is technically source income, because it is still sitting in South Africa. But if you are sitting in a different country and there's a DTA that deems you an exclusive resident and that basically dictates the taxing rights of the amount in that country, then it might absolve you from taxes in South Africa. Right. So, of course, then that would result in South Africa losing out on the tax on that retirement lump sum twice, because you didn't pay taxes on it when you ceased to be a resident, because it's not part of Section 9H. But now, even though you access it when you retire, or even if you don't retire, but now you've complied with the 3-year non-residency rule, now you withdraw it. Now they can't tax it because now it's subject to tax in a different country and the DTA doesn't allow them to tax it. So that's where this is coming from. It's still a work in progress. I think there's still a lot to be said and to be changed surrounding the scenario, because the way that they have proposed it to be done doesn't sound very fair towards taxpayers. It indicates that you will be taxed on it when you cease to be a resident, but then you only have to pay the tax when you get the money out of the fund, but then you'll also pay interest on the taxes that you haven't paid yet, which doesn't sound very fair to me. So it is still a proposal. It's not effective yet. Please don't worry about it and have sleepless nights, but also please keep an eye on what National Treasury says with the tax amendments that they're going to publish now for comment, the draft amendments for comment. If it comes through, please, if you are an interested party or a stakeholder and you want to submit comments, please do participate in that, because this affects individuals. So I think the individuals should be involved in this process as well. And then we just asked a last few questions. What don't we know? So the law currently states that you can only withdraw your funds if you are a person who is not a resident for an uninterrupted period of 3 years or longer, on or after 1 March 2021. So technically, this means that you already need to have been non-resident for at least 3 years by the effective date, which does sound a bit unfair, but that is the way I interpret legislation at the moment. Now, if you emigrated before the 1st of March 2021 and you have been a non-resident for at least 3 years, you should still be fine. Of course, you might have already accessed it if you emigrated before that time. Now, SARS's guide on the tax directives, they indicate a situation where with the definitions of your preservation and your retirement funds that were amended, they allow you to access your funds if you have ceased to be a resident, even if you ceased to be a resident before 1 March 2021. There we go. So in that case, you should still be fine, but you should have already requested to access your funds by the time that you immigrated. Now, ladies and gentlemen, this rule doesn't necessarily mean that if you cease to be a resident before the 1st of March 2021, that you don't have to be a non-resident for 3 years anymore. So that's why I'm saying, even if you left before, the new rules might still be applicable to you, regardless of when you left. The guide, unfortunately, also states elsewhere that for your retirement annuity fund members, you had to have been non-resident for 3 years in a row on or after the 1st of March 2021, which is basically in line with the current legislation. So even if you emigrated before then, the 3-year non-residency rules might still apply to you. Now, the second question we asked there is, what if I left without formally immigrating, but I also don't plan on coming back? Now, but please still notify SARS. You still have to notify them at this stage, because if you are still deemed to be a tax resident, then you are basically being taxed on things you shouldn't be taxed on. So please do let them know. Of course, if you do it in retrospect, it might result in penalties on the exit tax if you never paid it. So I would advise approaching formal tax advice. This process is actually best supported by formal tax advice, really good formal tax advice that have the legal backing, the ex-con or exchange control rule backing, etc., so that you can have someone walk you through the entire process. You still need to be able to prove your non-residency for 3 years in a row. So if you can do that, your RAF withdrawal shouldn't be a problem. It's just the rest of your tax compliance, because you didn't declare your non-residency or your change in residency, you didn't pay your exit taxes, or you may not have paid it. So that non-compliance might then impact the TCS that you need to withdraw your RAF. Now, it is possible to backdate your actual immigration or your actual break in tax residency based on the date that you left the country. Ladies and gentlemen, if that's what you want to do, please just take the retrospective tax application into account, your exit tax and the penalties, etc. And of course, you have to be able to prove it. Anything you do with SARS, you probably have to be able to prove it. Right. And then, of course, we asked the question there, what if I have been tax non-resident before the effective date, but not for 3 years? Unfortunately, the way the legislation is written at the moment and the way the guides indicated at the moment, it seems that you have to have been non-resident for 3 years by the effective date already, which does seem a bit unfair. I do realize that, ladies and gentlemen, but please note that I cannot change the law, and this is the way I interpret the law. So you might differ in opinion, but it seems like the guides also indicate that. You could have ceased to be a resident before the effective date. The law doesn't say that you have to cease to be a resident on the effective date, but it does require you to have been a non-resident on or before. On or after. For at least 3 years by the effective date. Now, the last question there, and this seems to be the unanswered one at the moment. The rest are at least partially answered in terms of the law and SARS's guidelines. But what if my immigration request isn't finalized by that cutoff time, the 28th of Feb 2022? And what if this isn't my fault? What if it is due to delays outside of my control? We don't really know. We don't really know at this moment what SARS and what the Reserve Bank's commitment is towards this. I suppose that their commitment is to work on it as best as they can to prevent this from happening. But I do hope that in the event that the process is delayed, that you won't be penalized if it isn't due to your own errors or your failure to cooperate. If you did everything you could from your side, then you shouldn't be penalized. That is my belief, that is my hope, but I can't guarantee it, right? Because there isn't really much guidance on this at the moment. Right, and then just a few last notes, ladies and gentlemen. We've looked at all of this, and we can see that SARS really now plays a big role in approving your immigration, your exit from the country, basically saying goodbye to future taxes that they could have collected from you. So you might also want to expect an audit or a verification from them, not because they're trying to be finicky, but just for being diligent, especially if you have been working abroad for some time now, and you didn't formally immigrate, you didn't formally indicate that you ceased to be a resident. SARS might investigate it. And of course, we need to take into account the new international sharing of information, your automatic exchange of information. There are a lot of tax authorities that can now work together to basically catch you, if we can use that term. Ladies and gentlemen, I always say honesty is still and always will be the best policy. With SARS, you don't want to be caught out later on and pay penalties and interest and have criminal offenses, etc. Right. And please also take note of the changes to the TAA, the administrative provisions for taxes. Negligence is now just as bad as willful non-compliance. You don't need to have intent. SARS doesn't need to prove that you have intent. If you just left it because you weren't feeling like it, but you knew you should have done it, then you could still be held liable for it. So if you plan on immigrating, please start the process early on. Please make sure that your taxes are up to date, because that can on its own, it can easily delay the process so fast. And always consider your DTAs. If you interpret your DTAs, if you utilize them correctly, you might just save yourself some significant taxes. And the last note, we've mentioned this a few times, please do get expert advice. Please make sure that you know your residency status and that you know what's going to happen once you immigrate and afterwards. We indicate here once again, we did this in our last session as well, tax admin really does cause a big headache. And you don't want to be sitting with that if you could have prevented it, not necessarily very easily, but at least you had some way of preventing it. Right, we've included a lot of links here to SARS's guides, SARS's web pages, the Reserve Bank's web pages with the FAQs, the manuals, the exchange control documents, all of the circulars, etc. And also just some links to National Treasury's documents with regards to the tax proposals and their comments on the immigration process. So you're more than welcome to have a look at it there. We also have a few of our own guides, practice manuals, that you can have a look at on our website. They are available for purchase. I would advise looking at the POPI manual at least, because it does become effective quite soon. And then we also have some tax guides on our side. The pay-as-you-earn guide for employers is now available. It also incorporates other labor law matters, your BCA requirements for leave pay, etc., the UIF and SDL requirements, your compensation fund. So all of those elements are covered in our guide. That is then the end of my session for today. Thank you very much for listening in. We do appreciate it. If you have any questions, please do send them through to our site. We will tend to them as soon as we possibly can. Otherwise, have a fantastic day, and we do hope to see you in our future sessions.